Okay. Good afternoon, everyone. Welcome to the board's July 24th to 25th, 2018 board meeting. My name is Victor Law, president of the board. As I call this meeting to order, I would like to advise all members of the public, both present or watching the meeting's webcast, that the board is a consumer protection agency subject to the Open Meetings Act. Members of the board may be using an electronic copy of the meeting materials. Please be advised that such members are using their devices for this purpose and are not communicating with each other via email or other electronic means. Given the start time of the meeting today, the board will not be taking a lunch break. Tomorrow, the board intends to take a break for lunch if the business of the board can accommodate such a break. I would like to remind everyone present who is interested in receiving continuing education credit to remember to sign in and out on the designated sheet in the back of the room. This meeting is being webcast. We respectfully request that when called upon to speak, please come to the speakers' tables and speak directly into the microphone. This will ensure those individuals watching the webcast are aware of all discussion and actions. I am pleased to announce some changes to the board membership. Ricardo Sanchez has been reappointed to the board as a public member. I would like also to welcome Ms. Shirley Kim and Ms. Maria Serper to the board. Ms. Kim is an attorney and has been appointed as a public member. Dr. Serper is a pharmacist at Sutter Medical Center and has been appointed as a licensee member. And thank you all for attending, and I look forward to a productive meeting. Now I would like to take a roll call and establish a quorum. So let's start with my left-hand side.
My name is Stan Weiser. I'm a licensee member, and I'm representing area code 92355.
My name is Shirley Kim, and I am an attorney, and I'm a public member.
I'm Lavanza Butler, licensee.
Hi, I'm Maria Serpa, a licensee.
Greg Lippy, public member.
Victor Law, professional licensee member.
Albert Wong, professional member.
Alan, oh, excuse me. Go ahead. Oh, sorry. I was just excited.
This is my moment.
I know it. I'm
We're
sorry.
being webcast.
I know it. Go. You're going to do a good job.
Debbie Vio, professional licensee.
Alan Chad, licensee member.
Bardo Sanchez, public member.
Okay, so a quorum has been established. So first business first, we need to bring in our deputy attorney, Mr. Chris Schultz, to come in and swear in our new board members. Mr. Schultz, please.
Chris. Excellent. Please raise your right hand. I state your name. Do solemnly swear that I will support and defend the Constitution of the United States
That I will support and defend the Constitution of the United States
and the Constitution of the State of California
and the Constitution of the State of California
against all enemies, foreign and domestic,
against all enemies, foreign and domestic,
that I will bear true faith and allegiance
that I will bear true faith and allegiance
to the Constitution of the United States and the Constitution of the State of California,
to the Constitution of the United States and the Constitution of the State
that I take this obligation freely
that I take this obligation freely
without any mental reservation or purpose of evasion,
without
any mental reservation or
purpose of evasion,
and that I will well and faithfully discharge the duties upon which I am about to enter.
and that I will
Well
and faithfully discharge the duties
Upon which
upon which
I'm about to enter.
I'm about to enter.
Congratulations. Thanks so much.
Thank you.
Thanks so much.
All right, thank you, Mr. Schultz, and welcome to our new board members. We're really excited to have you two join our board. And before we proceed to the next agenda item, we have a little announcement to make by our EO, Ms. Jeannie Harrell.
You know it's bad when I grab a statement, right? Okay, well, I don't know if it's bad, it's just going to be long. All right, I've sent the following memo to all of the board staff immediately before today's board meeting, as in just about 10 minutes ago. So this also pertains to the board. To my pharmacy family, at today's board meeting, I will announce that at the end of 2018, I will retire from the board as executive officer. I wanted to share this notice with you before I make it public, which it now is. I have had the great pleasure of working for the board since 1990, 16 years as the assistant executive officer and 12 years as the executive officer. Over these years, through our combined efforts, we have stepped forward to create a significant and relevant agency aimed at ensuring patients receive the medications and the quality pharmaceutical care they require and deserve. We have accomplished so many things, I hesitate to compile a list in fear of overlooking some of our major achievements. To give you some idea of where we once were, I will relate that when I first came to the board, we shared computers, which is an incredibly ancient concept to the way everyone does business today. It has been my privilege to have held these positions in public health for the years that I have. It has been through our combined efforts that we are positioned where we are, the nation's leading board of pharmacy, and if not, sorry, I need my glasses now, and if not the most, certainly the most significant among the most significant consumer protection agencies in the country. We are sought out as participants in evolving public health issues, an accomplishment that is noteworthy to acknowledge. Behind me, the board will be in effective hands with Ann Sodergren, who remains once I leave while the board determines its future. Thank you for all your hard work. While the board will continue to address exciting and difficult public health issues relating to such items as opioids, compounding, drug take-back, and new delivery systems for medications, I know you will be up to the challenges that will arise. I entered public service with sights on emulating consumer advocate Ralph Nader as my career goal. I am humbled to acknowledge that through our efforts, I believe I've succeeded in reaching part of that ambitious goal. Thank you. This has truly been a team effort, and I believe a job well done. Thank you all very much.
Thank you, Ms. Harrell, for your valuable contribution to the board. Laura, do we need a motion to approve the retirement from the board? We don't need a motion. Okay, so it's been approved. All right, let's move on to agenda item number 2, public comments not on items not on the agenda or agenda items for future meetings. Is there any public come forward to the mic?
Hello. Joe Grisella from University Compounding Pharmacy.
Phone next to it or anything?
Joe Grisella from University Compounding Pharmacy. What I would like to do is place on the agenda for future meetings in the Enforcement Committee other boards of pharmacies in the United States prior to having a person placed or a pharmacy placed on probation usually goes in front of the board. And at that point, the board listens and decides if the probation should go further. I think that is a very fair thing to ask this board to do, because there are two sides to every story. And the only way that you can really bring your side to the story in front of pharmacists would be to come to a Board of Pharmacy meeting like this. This is very common, and I think, like I said, it's the only real fair way that someone can give out their presentation, and as there is two sides to every story.
Oh, before you go, Joe, could you tell us the boards that you've had experience with that did that? Not publicly here, just
Well, the last one for sure was Indiana, and they heard my presentation. Texas, Pennsylvania. And just so you know, what happens is that you will get a notice that you are possibly going to be placed on probation. At this point, we want to see you. And I think it's a good idea for the Board of Pharmacy to see this person, because if they have done something serious, well, you know, you want to see this. But what if there's other circumstances? And out of the almost every board that I went to, everyone dropped the case except the boards that did not have any choice, because once California puts on the board, then you're automatically placed on the board on probation. So I think this is just fair. I think the board would want to hear the reasoning, not towards the end of the case or 2 years later for, you know, early termination for the first time they're hearing about it. Thank you.
thank you.
Thank you, Joe. Any other public comment? Okay, if not, we'll move on to agenda item number 3, approval of the May 2nd and 3rd, 2018 board meetings minutes. Any amendments, any
Yeah, I've just
corrections?
got a couple
Yeah, Greg.
typos here. Nothing major, but on page 40 of 55, AB 2789, the summary says that it's required by January 1st, 2021, and it's actually 2022. Oh, it is now 2022.
Right, it was the prior version of the time.
Okay. And on page 53 of 55, 2 paragraphs up, Secretary Treasurer, I believe that was for the UFCW as opposed to the USCW.
Okay.
And that's it.
This one.
I missed one.
Recommendation should be at 1442. Last line on the second page. Thank
Hey,
you, Greg.
I stand corrected. Thank you.
All right, thank you, Greg. Any other corrections?
Yeah, I had one.
Wow.
You want to go first? Did you have one,
Okay.
Cheryl?
Okay, Cheryl. The microphone, Cheryl, please.
Yes, on page 32, where Ms. Howard reported she and board member Victor Law attended the California Pharmacy Association Pharmacy Exchange. My name should be added to that. I was there.
Yes, she was there. Okay. Okay, and, okay, Debbie?
Okay, on page, okay, on page 2, March 27th board minutes, I believe I voted to abstain because I did not attend the March 2018 board meeting. It shows I supported, but I believe I abstained.
Okay.
Which one was that?
That was
The
page,
March 2018 board minutes, the motion to approve them, I abstained because I did not
Oh.
attend that meeting.
all right. Any other corrections? And I do have one here too. That's on page 31 of 55. At the bottom, it says Ken Brown, a former board member and faculty at UCSD. What should be Ken Xiao?
Yes?
Yeah.
Right? So instead of brown, it should be shell. Thank you. Okay. All right, hearing all this, I need a motion to approve this minutes as amended.
So moved.
Moved by Greg,
I'll second.
second by Debbie, and all those in favor, please raise your hand. Okay, object and abstain. Got it, Laura? Okay, thank you. Let's move on to agenda item number 4. Approval of the June 6, 2018 board meetings minutes. Any corrections from board members?
I move to approve.
Motion by Debbie to approve,
Second.
second by Greg. All those in favor, please raise your hand. Oppose or abstain? All right. Okay, thank you. All right, next item, recognition and celebration of pharmacists licensed in California for 50 years. I understand we have one person in attendance here. Dr. Clifford Wong, are you here? Please come up.
Right.
Okay. Dr. Wong, please, welcome. Why don't you introduce yourself and tell us something about yourself?
I got a speech. No, actually, in today's parlance, I would be considered a PG-50. Okay, my name's Clifford Wong. I graduated from UCSF in '68. Unfortunately, I missed the Summer of Love in 1967.
Really?
I was just too busy studying. So I did work a little bit in community pharmacy on the corner of Broadway and Grant, where they had those topless shows.
Yeah.
And then I decided this isn't for me. I went to join managed care, worked at Kaiser Permanente, and I started as an intern pharmacist, and I was fortunate to be able to rise to the top position as the director of pharmacy operations in Northern California, not Southern.
Wow.
So I think that was the best job I ever had. I think it was at that time the best job in the United States. I had the ability and the team and the people to affect pharmacy benefits that were affordable, accessible, and of a high quality. And then I retired from Kaiser after 32 years, went to work for a PBM named MedImpact in San Diego, did that for 12 more years, was the vice president of government programs and services, and brought Medicare Part D to the marketplace for them. So I survived lots of turmoil business. I survived multiple, reorganizations. I came out alive. And so what do I do now? I travel, I bicycle, I can still do 25 to 50 miles, I ski, and I belong to the ski club, Spend Kids Inheritance. So it's been a great run over a half century, 56 years if you include pre-pharmacy and pharmacy school. So I'm 73, and I hope to have many more years to enjoy the fruits of my labor. My vision of a perfect exit is that I will be skiing at Heavenly, around that big curve onto the ridge run. My chariot of fire awaits. I ski on and ascend to heaven. So, Ginny, it's all good.
I hope so. I'm
So-
counting on it.
Yeah, so it's been good. Any students in the audience? Residents? Oh,
Not today.
not today. So the trick is to, you got one? Oh, I would say have fun and enjoy it. Don't miss your summer of love.
I'd like to say if we were.
Oh, hey, Albert.
You remember my name? Yeah. I thought I never met you before. I always heard your
You
name.
got the same name.
I mean, when we heard your name, we start shaking. Yeah, I was at I'm sure you, like I say, this is my first time I recall meeting you, but I'm surprised you remember me. I was serving at Kaiser under Lolita. Julia Reed's Lolita. I was up there at 1976, 77 until I graduated. So I'm sure you worked with a lot of my classmate, roommate, Stephen Choi, Frank Young, William Toy. So we heard a lot about you. So it's a pleasure to see you doing so well and looking in such a great shape, and keep skiing. I think I will get back to it too. I haven't been skiing for a while. I'll get back to it. Well, it's congratulations and thanks for all the contribution to our profession.
All right, thank you.
Thank you.
Any family members or other friends with you? You could invite them up for a photo? No?
Well, I would consider Steve Gray a friend.
Steve Gray, a friend.
Colleague.
All right, Steve, you want to come up and we'll take pictures together with Dr. Wong? Yeah. So here's your 50-year pin from the Board of Pharmacy.
No, after we enter our professions, this guy drives better cars than me.
You look great. You're in good shape.
Hey, well, I think I belong to the best health plan, Kaiser Permanente. That's commercial. I forgot. This is being televised.
All right, let's take a picture here first. Lauren?
Right here, guys. 1, 2. Oh, look good. Any other pictures you want?
No, that's it.
Congratulations.
Yeah, come on, Jenny. One picture with you.
We used to run
I think the Kaiser people will be surprised.
Oh, yeah.
Come on down here, Jenny. Right here.
Well,
Hey.
All right.
Okay.
remember all those planes? We were always on Southwest.
3.
All right.
Or whatever it was before.
Great.
Congratulations on
50 years. Hey.
Okay, here is your 50-year pin from the Board of Pharmacy, and congratulations, and thank you for all your years of service.
Absolutely. Thank you.
All right. Well, that's good news. Looking ahead, look at all the pharmacists are doing so great, even in their 70s.
Yeah.
See, Stan, you are not alone.
Good.
All right. Let's move on to the next agenda item. Presentation of the administrative case process and case resolution times for matters referred to the Office of Attorney General. Okay, Josh.
Trying to build some excitement.
Hope you all have your coffee this morning. Are
like
you
you
going to
did.
want to see my slides, or do you have copies of them?
Actually,
You
do
have
have
copies, that's fine. We'll save the excitement for the audience. Okay. Can you guys hear me? I don't feel like these are working. Are they working? Okay. Man, I'm just so loud all the time. Who can tell? All right. So this presentation is basically an explanation of what happens once a case is referred to our office for prosecution. And one of the goals, I don't think it's playing. Exactly. Do you see it up there? Okay. Greg's going to be my co-presenter today, apparently. So one of the explanations, or one of the sort of justifications for this presentation is to sort of explain why cases take a fair amount of time to prosecute. Yeah, exactly, fair. Fair being the operative word. Justice grinds slowly, as you may have heard. On average, for all of our client agencies, I think disciplinary matters referred to the AG's office typically take about a year from start to finish on average. Now, obviously, some are faster and some are slower, and some client agencies have instituted certain programs to make them faster. It's harder to expedite Board of Pharmacy cases because they tend to be more complicated. They tend to involve more respondents, more parties, more complicated facts, longer investigations, things like that. So I'm not saying that we can't possibly get under a year, but I think a year is a fairly strong average for what it's going to take for Board of Pharmacy cases. So as you probably already know, the Attorney General's office represents almost all state agencies, including the Board of Pharmacy, in any case that might require a presentation to outside, to a court, to administrative tribunal, anything like that, any litigation-based case. You have in-house counsel that doesn't do those kinds of appearances, so we represent you in any litigation case. Just the mission statement of the Attorney General's office, and I'll just emphasize the second bullet point here, because one of the reasons that cases take a long time to prosecute is because California is among the nation's leaders in terms of guaranteeing due process for every litigant in a case like this. And when you guarantee due process, that means there's a certain amount of time that's taken to make sure that everybody has the right to present their own case, has the appropriate amount of time to be served and respond to the case. So that takes a certain amount of time. Yeah.
One question going back, you said for all the clients that your office represents, it's about 1 year. Do you know what the average is for us?
It's about a year.
Oh, it still is about a year
Yeah.
for us?
Yeah. I mean, Ginny received some stats. We can give you the actual stats at some point, but Ginny received some stats from my boss, from the senior assistant, about 2 months ago. And those showed an average of about a year, a little bit more. And this is sort of the point of licensing. And, you know, the enforcement of licensing laws has 3 main objectives. One is to remove from practice anyone who might be actually dangerous. Another is to deter others from engaging in that same conduct, which is one of the reasons that the disciplinary cases are publicized. And the third, and perhaps most important, is to maintain the integrity of the profession and promote public confidence in everyone who has that license. To some degree, at least, the license that licensed professionals receive from the state is meant to be some sort of guarantor that person can be entrusted with your professional needs or your vocational needs. And so we want to make sure that seal that the state gives you maintains the same meaning that it's been taken to mean. So this is the rough breakdown of all of the clients of the licensing agency. Approximately 60% of them are healthcare related: pharmacy, pharmacists, chiropractors, social workers, nurses, things like that. And then about 40% are non-healthcare, which are automotive repair, contractors, things like that. And this eye chart is a rough depiction of what happens in a case from the moment it comes into our office until it may come to you for either stipulation approval or approval of a proposed decision. This is intended to show all the way through the hearing process. So as you can see, there's a number of different steps that have to be gone through in every case. This is basically what the attorney does from the moment that the case is received in the office, including the supervisor. And I'm going to talk about each of these steps in a little detail so you get a better sense of them, so you don't have to remember this eye chart, but just sort of know that this is it generally divides into these 3 phases. Feel free to stop me at any time if you have any questions. So when a case file comes into our office, it's initially received by someone like me, a supervising deputy attorney general. There's typically at least 2 in every office except Oakland, which only has 1. And we screen the cases initially, and we're screening them for several things. First is whether it's geographically in the right office. We have several offices throughout the state: San Diego, Los Angeles, San Francisco, Oakland, and Sacramento, and a small presence in Fresno. So we have the state divided up geographically according to which office is supposed to handle cases emanating from which locations. And so the first thing we check is to make sure it's gone to the right city, because sometimes, people don't know exactly where things go. So sometimes we get misdirected files. Then we look to see if the case needs to be expedited for any reason, either a reason identified by the client like it's an ISO or a PC-23, or if it has a statute of limitations issue that either the client has or has not recognized, and we might need to get it under a statute of limitations. Some of our client agencies.
So what's an ISO and a PC-23?
So an ISO is a petition for an interim suspension order. So this is it's sort of like a temporary restraining order. It basically allows us to go before an administrative law judge and seek a temporary suspension of that person's practice, whether it's the entity practice as a pharmacy or the individual practice as a pharmacist or pharmacy technician. So there are two findings that have to be made. One is that there's been a violation, and two, that that person represents an imminent threat to the public in some way. So, and the thing about an ISO is that it might seem like you'd want to do those a lot more, but it really requires you to speed up the process, because once you've issued an interim suspension order, you have to file the accusation within 15 days after its issuance and have the hearing on a very expedited timeline. So we can only do an ISO when we're actually ready to proceed with the case. We can't go in on a sort of preliminary basis. So sometimes an ISO makes sense, sometimes it doesn't.
Jenny, I was thinking, I don't know where she is. Oh, there you are. I was thinking that there was a way we could actually even get it to be sooner, because, I mean, to have to wait to give it to the Attorney General's office and have them kind of go through, but if, like a compounding issue, if we see that there's...
We have some wonderful tools that are in addition to this. One of them is the ability to issue a cease and desist, which allows me to go in and say, stop now. We then have 30 days to resolve the matter or ask the entity to continue for another 30 days, although we have no requirement beyond that. So we have to be ready with whatever enforcement action that we need within that 30-day period. And again, they're kind of draining and they're resource intense, because we have to have the Attorney General's office be right on top of it to ensure that the company, because we would only issue this if we didn't want the company to resume unless it could go back and correct totally the deviation. We would want to stop the practice, so we have to have our attorneys ready to go. Which one of us is doing this? Geez.
If you have a phone near a microphone, please move it away.
Anyway, but we have, that is a wonderful tool for us, and so we do have the ability to use a cease and desist order for that. And we also, if we uncover unlicensed activity, we have a cease and desist order for the same thing.
Right, there's only two areas where the board has cease and desist authority. One is relating to compounding and one is related to unlicensed activity. Those are the only areas where administratively, without intervention by our office, without going to administrative hearing or other kinds of proceeding, the board could also seek injunctions in Superior Court, but that's so rarely done that it's not really on my slide, because that's a much bigger undertaking. But in theory, you can also seek an injunctive relief kind of order from a Superior Court.
Gosh, where we have a pharmacy like one we had, where they were dispensing dangerous drugs to numerous people, which resulted in the deaths of 4 people. It took 4 years before we were able to do anything. The cease and desist would not have applied to that situation.
That's correct.
Is there a way that we can get the cease and desist to apply to situations like that?
I mean, you can certainly, by statute, by legislative enactment, get additional cease and desist authority.
That's the only way.
Yeah, that's the only way you'd be able to get more cease and desist authority. And I don't know the details of that case. I don't know which case you're talking about, so I don't want to discuss it in any detail. But one thing I can say is, quite often when there are patient deaths, typically one of the reasons those cases take so long is because there are criminal proceedings that precede, that we want to give precedence to over the administrative proceedings, for a couple of different reasons. If it's not obvious to you, I'll just say a couple of reasons, and if you want to know more, I can tell you more. But a couple of reasons we don't want to go first are, we would typically be using the same witnesses, and if we go first, we give the possibly free discovery to the defense side, and may foul up the criminal case in some way. And secondly, if we happen to go forward and lose, we might, through a legal proceeding called collateral estoppel, we might prevent the criminal case from going forward. So we have to be careful that we don't interfere in criminal proceedings by going ahead of them. That doesn't mean we don't always. Sometimes we do. We can communicate with the DA's offices and figure out who should go first and whether we can segment the case or bifurcate the case and do certain procedures. But quite often when it's a very serious case and it seems like it's the one that should go the fastest, I understand how frustrating it is, but there are reasons that the most serious cases actually take the longest.
Okay,
Did you answer PC 23?
I know, but I'm about to. Thank you for reminding me.
Okay.
Would you like to do this tour with me?
He gave the seat to Greg, so.
I knew you were going to be resentful about that. PC 23. PC 23 refers to the Penal Code Section 23, and this is where anybody who has a license from any state agency, or most of the state agencies, at least the DCA state agencies, if they are the subject of a defendant in a criminal proceeding, the agencies, through my office and my office separately under another code, have the ability to appear in those criminal proceedings and ask the criminal court, as a condition of release, either bail or own recognizance release, to prohibit that person from continuing practicing under their license during the pendency of the criminal case. So in other words, the bail order would say, okay, you're out on $100,000 bond and you're not allowed to practice as a pharmacist until this case is resolved. So we do that quite frequently. That's actually a less resource intensive and more expedited way of getting someone out of practice than, say, an ISO would be in that same circumstance. So if someone has a criminal proceeding, we will almost universally go in on a PC-23, depending on the seriousness of the crime. But most of the time, if it's a crime that we consider to be a threat of any kind, we will go in on a PC-23.
Oh, but before you get started, again, on the statute of limitations, does that apply to many pharmacy cases?
No, there are only, I think, 4 of our client agencies. Maybe, I'm not sure, but there's at least 3 of our client agencies that have statute of limitations. The Board of Pharmacy is not one of them. Now, for those of you who may not know what a statute of limitations is, let me just, I'll insult all of you by telling you what it is. A statute of limitations is basically just a decision made by the legislature that for certain crimes typically, but also for civil claims, a certain amount of time is the reasonable amount of time that a defendant or a defendant as a civil matter can reasonably expect that matter will not be brought. So most of our client agencies that have statute of limitations, they're 7 or 10 years, depending on, 7 years for obvious things and 10 years for things that could be concealed. And then there's usually an additional kicker that gives the agency another 18 months from the time it was reported to them. So for instance, if something goes on for a really long time in civil litigation and it's only reported to the agency at the end of that time, then the agency should still have its time to work on that case. So a statute of limitations makes some difference in terms of how fast cases go, but really all it requires is that the case be filed within that period of time. So you can always file a case and then follow up. So it doesn't necessarily make the case go any faster.
Josh, this is Laura. Sorry, do you mind if I interject just a teeny bit on that? And I think the statute of limitations and the lack of one that applies to licensing decisions is consistent with the principle that licensing is about public protection, and that the idea is that if there is a problem with a licensee that needs to be addressed, that may still exist. Does that make sense? And during that time, there still might be mitigation or rehabilitation, but if there's a competency problem, the statute of limitation, the lack of a statute of limitations allows the regulatory body to go forward if there's a need.
Yeah, and I said this during my initial presentation, and I'll just repeat it now. Most of the time, any delay in the prosecution of a case more often than not accrues to the benefit of the respondent or the defendant because, as Laura just mentioned, they've had additional time to show that they've been mitigated, they've mitigated the behavior, or they've been rehabilitated. The other thing that can happen is, that mic just can't handle me. The other thing that can happen is there are legal principles that apply regardless of whether an agency has statute of limitations. There's a legal principle called laches, L-A-C-H-E-S, which basically means that if the agency or any prosecuting body has taken too long, then you have a civil or a equitable remedy against it. So there's two showings that the respondent would need to make in order to have laches apply and bar the case. One, that the delay has been unreasonable, and two, that delay has prejudiced their case in some way. So if, for instance, witnesses have disappeared or documents have been destroyed or something like that in that intervening period, and it's as a result of that intervening period, then there is a way in which people, even without a statute of limitations, might be able to bar a case. Now, as Laura also mentioned, because there's such a strong presumption in favor of public protection in the licensing realm, and in the absence of a statute of limitations, courts are very, very reluctant to ever apply that principle in this domain because the presumption is in favor of protecting the public and against the interests of the respondent. So just so you know, there is this equitable principle, but the stronger equitable principle is that the public ought to be protected by these consumer protection laws.
Just curious. So what are the boards that they have the statute of limitation?
Which ones do?
Which one they do?
Contractor State License Board has one. Dental Board has one. Medical Board, Accountancy. Do you know of any others, Laura? Those are the ones I can remember. But as I said, those statutes of limitations are things like, typically like 7 years or 10 years. Dental Board is a little shorter, but it has an extension. Some claims are not subject to the statute of limitations, like fraud is not subject to the statute of limitations for the Dental Board. So once the case comes in and is reviewed by a supervisor, we slot it according to the matter type, and I'll just list those matter types. There's accusations, which, as you know, are affirmative cases seeking discipline. I'll just go through these for the new board members. A statement of issues is a case where someone's applied for a license and been denied. This is the pleading that's filed after their appeal of that denial. A petition to revoke is for someone who's on probation and has done something to violate the terms and conditions of their probation, and this is brought to revoke that probation and either extend their probation or put them on or revoke their license. As I mentioned before, an ISO is a petition for an interim suspension order. Penal Code Section 23 refers to those criminal proceeding appearances. 820 is for a physical or psychological evaluation of a licensee based on perceived impairment. So we bring a petition in order before the board president to sign to have someone examined by a physical or mental health examiner. Most often that's someone has exhibited some behavior or some impairment that doesn't rise to the level of unprofessional conduct necessarily on its own, but it is cause for concern and reason for investigation. So once the case comes into our office, the goal is always to have that case assigned within 10 days and opened within 15 days, same 10 plus 5. So the way it's opened is too mundane to go through, but it's a somewhat complicated process to get into our electronic case management system in our office so that we can keep up with all the milestones and keep the case going on the same path that everybody wants it to be on. So that's the goal, is that within 15 days the client will receive an acknowledgement letter telling you to which attorney the case has been assigned, and that all communication should be with that person, with that DAG and that DAG's supervisor.
Hey, Josh.
Yeah.
Not necessarily in Northern California, but it seems in Southern California, from time to time, there are more delays with assignments than there are in Northern California. Is that just my impression, or is that...
No, and I'm glad you actually asked that question, Stan, because one of the things that happened is, for those of you who've been around
for a number of years like Stan has. And I don't mean in life, I mean on the board.
No offense taken.
Several years ago, there were various initiatives spawned by various press reports that led to kind of a hardening or a swing of the pendulum toward the enforcement side of all the boards and bureaus. And the Department of Consumer Affairs had the Consumer Protection Enforcement Initiative. There was lots of additional resources poured into, expediting cases, hiring more investigators, hiring more staff, all these kinds of things to generate more cases and make sure more licensees were being tracked and monitored and so forth. That additional workload was not met by a commensurate increase in the number of attorneys in my office at the time. And the understaffing was particularly devastating in Los Angeles because Los Angeles had a huge number of attorneys turn over. So it's not surprising, and I am very compassionate for my brethren in Los Angeles that they were severely understaffed for a long time. They just got a BCP last year or a year and a half ago, and they're just now in the final stages of a hiring process to come up to speed with enough attorneys, hopefully, to really not have that problem in the future. Unfortunately, at the same time that's happening, we've had 3 or 4 positions open up in the Bay Area and 3 or 4 positions open up in San Diego, just based on retirements and natural turnover. So it's a constant, battle to stay ahead of the curve. But yes, I think you're correct that for a time, San Diego, there was a time a few years ago when Sacramento was severely understaffed. So each of our offices has gone through its struggles. Sacramento is now fully staffed. San Diego was fully staffed, but is now going to lose people. So, yes, the answer, that's a long way of saying yes to your question.
Thank you.
So these are all things that do contribute to some of the delays you may have experienced in cases. The goal of our cases is to, within 90 days of receipt of the case, the Deputy Attorney General is supposed to have analyzed that case and prepared a pleading and sent that pleading back to the client agency. So that's what all of this is what are the things that the Deputy Attorney General is doing in reviewing the case. Obviously, they're reviewing primarily for the substance of the matter in terms of whether various violations that are alleged in the investigation report can be proven. We have an ethical obligation as prosecutors, or at least it's not clear in the law, but we at least feel ourselves bound by an ethical obligation as prosecutors to not bring a case unless we are persuaded that we can prove that case by whatever the burden of proof is. And I'll talk about burdens of proof in just a minute in different cases, but we have to be satisfied that before we file that case, we have that evidence, because as we all know, these documents are public filings, and just the filing of that document could very easily ruin someone's career, or at least severely divert it. So we want to be very confident before we file a case that we have met that ethical obligation. And each Deputy Attorney General feels that obligation, and in combination with their supervisor, goes through all of these things. A lot of this is just sort of the minutia of what they do, but there's also a lot of review of substance of the investigation to assess as much as you can on paper the credibility of various witnesses, to assess the reliability of the investigator and how competent their report is and how much they seem to have explored every investigative trail. Quite often we will request additional investigation, not typically in Board of Pharmacy cases, because Board of Pharmacy investigations are among the best, but lots of our client agencies don't have the same investigative quality staff that Board of Pharmacy does, so we often have to do that with some other client agencies. And then you want to make sure that the investigation has covered the entire universe of what would be possible in that case. If you see, if they sort of made a motion at possible fraud at the outset of their investigation but didn't really follow up on that, and you see that there's real potential for a fraud investigation, you might ask, is it worth investing additional resources in that? I mean, obviously that's a decision that's ultimately made by the executive staff, whoever, but we can make suggestions about other avenues that we see that might be explored. So that process can take a while, and that could take a significant portion of it could take more than 90 days for just to get the additional investigation. So that's one of the places where things can get held up. As I mentioned before, if there's a parallel criminal proceeding going on, you may want to wait at least some time. You may want to communicate with the DA's office. You may want to see if they have additional evidence that wasn't shared with the investigator but might be shared with our office, things like that. So these are all factors in how quickly a case moves forward. And so far, all the factors I'm mentioning have nothing to do with staffing levels, the particular diligence or competence of a particular attorney or anything like that. These are factors that apply in every possible case. And then, of course, there is variability among our staff. I think all of our staff are pretty excellent and professional, but there's always going to be different people that are faster and slower than others. So that's the sort of general process of what the assigned DAG does when it first comes in. Then, as I mentioned before, they have an ethical obligation to really review that investigative file, make sure they're comfortable with everything in it. They may want to, this is uncommon but not unheard of, in cases, particularly say like a sexual abuse case or some case where the case will depend entirely on one witness or a couple of witnesses and their credibility. Some DAGs may want to communicate with those witnesses before they file the case, just to get their own sense of how reliable those witnesses are and how much they might hold up under cross-examination or at hearing. So that's another thing that can take a little bit of time, is just making sure that the case is strong before you file it. There are sometimes documents that might be missing or documents that have to be gathered, and then witness statements and so forth like that. Quite often, this is less common in Board of Pharmacy cases because in Board of Pharmacy cases, the inspectors are themselves pharmacists, so they can provide whatever expert testimony we might need typically. That's one reason that pharmacy cases don't take as long as they could. But sometimes we do engage outside experts even in pharmacy cases. If it's a particularly, like in corresponding responsibility cases, sometimes we use an expert to sort of bolster the individual judgment of a pharmacist as to what is a reasonable expectation for a pharmacist in terms of, staving off abuse-seeking behavior. So if we do engage an expert, then that's a decision that the DAG might come to in reviewing the case. I know, for instance, in some wholesaling cases that Desiree and I have worked on, we've decided that board inspectors could be bolstered by someone with greater experience in the wholesaling world that a typical pharmacist might not have. So we've gotten some wholesaling experts to sometimes come in and testify about what's reasonable behavior for a wholesaler. And if we do need to get an expert, then obviously the case has to be sent to them for review. They have to either prepare a report or just report orally back to the Deputy Attorney General about what their findings are, and then some kind of contract agreement has to be made. All those things take time to proceed. After the file is reviewed, the DAG has essentially three choices. As I mentioned before, they can return the file for further investigation or to retain an expert. They can decline to prosecute, although we very rarely straight out decline to prosecute. Typically what we do is say, there's some part of this case that maybe we could file, but the meat of this case requires further investigation, or we could file on this but not on this, or we think we need more investigation even to file this. So typically when we are requesting additional investigation, we are telling in our communications, we're saying either we can file now, but we think it could be a better case, or we're saying we can't file now, even we need you to do further investigation if you want us to file. And sometimes executive staff or enforcement staff decide it's not worth it, that if it's going to require additional investigation, then there's no reason to proceed with that case. It was a minimal enough violation that it's not worth the expense of additional resources. Everything is a zero-sum game. There's only so many inspectors, there's only so many hours to spend on investigation cases. There's a lot of discretion that Ginny in her large number of years and Anne in her large number of years have seen all kinds of cases, know what cases are worth pursuing or what cases are likely to result in discipline. So that's where their experience is really valuable. And then finally, if all of the sort of criteria for filing are met, then they proceed to pleading, the preparation of the pleading, which, as I said, all of that, what I just described, is supposed to happen within the first 90 days after assignment of the case to the DAG. And I think we're generally pretty good at meeting that milestone. I think different offices, depending on staffing, have had different records, but in recent I think in the last year or so, we've been pretty good about hitting the 90-day milestone on average. Obviously, there's some cases that take longer and some cases that are a lot quicker. But I think on average, I don't know if Ann has those stats or not. Do you think we're hitting them? You don't know. Okay. One of the things we're doing in order to try to expedite that is that the supervisors and our senior assistant, Linda Schneider, who some of you have probably met, had a big meeting in San Diego in May, and we're really trying to do more standardization across the cities, as is true in many state agencies. There's always been a little bit of variation across the cities in terms of how cases are pleaded, which makes it harder for staff to know whether a cosmetic difference is material or non-material, whether they need to request an edit to make it look more like, the way I like it that Josh does it, but I don't, but this one looks different, but maybe it's just the same. So we're trying to take that out of the process, both to make review easier for the client agencies and to make it more standardized within our office so that pleadings can be done more quickly. So we've done a lot of things in terms of standardizing the format and the template. We've always had a standardized template to some degree, but we are trying to create more uniformity. There's still going to be lots of individual variations. And neither, in the licensing context, there is something called notice pleading requirements, which means that technically the only thing that's required is that the respondent be placed on adequate notice of what is being charged, identifies the statutes or regulations that are in question, and gives some sort of basic factual information about what he or she is alleged to have done that violated those statutes or regulations. But there's a huge amount of variation from that minimum to a much more factual and much more detailed pleading. And there are good reasons to do both in different kinds of cases. Sometimes you might want to do a really spare and minimalist pleading because that might encourage the respondent to settle because there's not as much to admit. There's not, their behavior has not been, put out in the world as much. They might be wanting to just make the thing go away more quickly. Sometimes you might want to make it more detailed because you might want the respondent to know that you know all this stuff and that there's, really no point in disputing it. Or you might want to let the respondent know that you're really serious about it and that, you consider all of these facts unprofessional conduct, things like that. There's lots of different reasons, and that each Deputy Attorney General has a different style, but we're trying to make those more uniform, but we also need to allow for individual judgment in individual cases. So then, once a draft pleading is completed, ostensibly within that 90-day timeline, then it goes back to executive staff, enforcement staff for review. Quite often there's a little bit of back and forth. There's less back and forth with Board of Pharmacy than there is with some other agencies, but the pleading is ultimately signed by the executive officer, so even though we prepare it and we make the legal decisions about it, there are some strategy decisions and some factual decisions that enforcement staff might have input on. There might be things, it's typically subjected to, I think, 2 levels of review, both enforcement staff and then the inspector and maybe even the supervising inspector reviews it. So we want to be really sure that we haven't misunderstood something in their investigation report, and because they're the final call on what the facts are of the investigation. If they have a typo in their investigation report and we've repeated that typo in the accusation, we really need to know that. If we've just misunderstood what the dosage was or what the drug was, we really need to know that. The worst thing we can do for our credibility is to file a case that's inaccurate. And we certainly don't want to do that in terms of impugning the integrity of potential respondents with allegations that are unprovable. So we want to be as sure as possible that, so sometimes that process takes a little longer than we might hope, but inspectors are busy, we're busy. Getting that accurate is really, I think, more important than getting it fast. So that's one of the reasons that can take a long time. Any questions about anything so far? Okay. So then once we get to the point where all of that work is done, then the pleading is signed by the executive officer, and Signed also means filed. Once a pleading is signed by the executive office, that means it's filed before the Board of Pharmacy. But then it has to be served on the other side, and there's various ways we have to accomplish service to their address of record. Sometimes they have multiple addresses. Sometimes they don't respond to the initial service, but we learn of an additional address. There's lots of ways we want to make sure that that person, there's a legal maxim that the law abhors a default. What that means is you want to make every effort to give people their day in court and not take their license by default, not, obviously there's legal requirements that they have to meet. If they don't return a notice of defense within 15 days by statute from service of the accusation, then technically a default can be taken and their license can be revoked by default. We typically extend it beyond 15 days, and then even if the person responds but responds very late, as long as the default has not already been entered, or even sometimes if it has, we still give them the chance to return a notice of defense. We basically bend over backward as much as possible to allow people to respond and have a chance to present their side of the story as opposed to having the case decided by default. So that can sometimes add in additional time as well. And what often happens is someone will respond initially without having consulted an attorney, and not every case requires an attorney, but some people feel more comfortable with attorneys, obviously. And so they may respond initially with an attorney, and then some months later they may engage an attorney, and though that doesn't restart the entire process, there's certain things that have to be redone once you have an attorney. Any negotiations you may have entered into with the respondent without attorney typically have to be redone with the attorney. The attorney, has to show their value added, so they may want to change the terms that were previously agreed to, things like that. So that's sort of the general response process. And again, the most important thing to know is that for an accusation or a petition to revoke any affirmative accusatory pleading, the deadline to respond is 15 days from date of service, not necessarily date of receipt, and that we don't hold that 15 days hard and fast. We typically extend it beyond that and give people additional opportunities to respond. So if the person does return a notice of defense, these are all the things that they can choose from. They can request for a hearing. We recently changed our notice of defense because sometimes respondents were confused by the fact that the statutory language says you're requesting a hearing, and so sometimes people thought, well, if I don't want a hearing, I don't know whether I should return this. They thought, I only want a settlement. I don't really want to go to a hearing. So we changed it to put language on there saying they can request a settlement, they can request a surrender, even though that's not provided for in the statute, just to make that more clear to respondents that they have options. Because I can't tell you the number of times I had that same conversation with someone where I called them up and said, are you going to respond to the accusation? And they said, well, no, I don't want a hearing. And I said, well, do you want to keep your license? Yeah, I want to keep my license. Well, then you need to return a notice of defense. So a notice of defense just keeps the case at issue. It just prevents a default. It's not actually, even though it's statutorily required to say that I'm requesting a hearing, that's a little bit of a misnomer. And if they don't file the notice of defense, then we prepare what's called a default decision, which can revoke their license by default. Then once the case is at issue, once the case is at issue, not coming up. What is that? Okay. Then we engage in what can be a drawn-out discovery process. We have a much lower discovery threshold than they do in civil litigation, but it's more like a criminal case where the expectation is basically our office will turn over everything we have in our investigative file to the respondent. And although respondents do have reciprocal discovery obligations, there's lots of times we don't get things or we don't get things on time. Defense counsel can delay the process. There's another legal maxim that delay is always to the benefit of the defense. And you can see that that's true in an accusation or petition to revoke case, because as long as that case doesn't go to hearing or doesn't settle, that person's still able to practice. So they want to extend that period as long as possible. It's only once there's a board decision that there's any, the filing of an accusation may have some impact on their employability, but doesn't have any order to it. It doesn't have any force to it until it goes before the board for either a stipulated decision in order or a proposed decision, which becomes a decision in order. So there's a certain incentive by respondents, and particularly by respondents' counsel, to push the case off as long as possible. So it's not uncommon for us to have our initial meet and confer with defense counsel, and which we're required to do before we can set a case before the Office of Administrative Hearings. We have to consult with them about a hearing date. And it's not uncommon for us to say, okay, when are you going to be available for hearing? Give me your dates of availability. And they'll say, well, I'm booked up for the next 18 months, or I'm booked up for the next 12 months. And so there's a couple different ways you can respond to that. One, you can say that's ridiculous. You must have dates before that. And then you can, second way is you can say, that's ridiculous. I'm going to request a trial setting conference before the Office of Administrative Hearings, and they're going to force you to put dates on the calendar. Neither of those ways really works. The Office of Administrative Hearings is somewhat reluctant to force anyone to, for reasonable, again, it all goes back to due process. The sort of general predisposition is to allow people to have their counsel of choice and to make sure that they have an opportunity to present an adequate defense. So judges are very reluctant to interfere with either of those rights. Obviously, they have some ability at the margins to affect that, but they're not going to, and they can't see defense counsel's calendar. They can't say you're lying to me that you don't have anything available for a year. So then you get to the third option, which is just to lock down the dates that you get from them and just put those dates on calendar. And that's typically what our office does, because anything else has proven to be not particularly fruitful. So that can build in a lot. There's certain attorneys that we know, if they're assigned the case, we're not getting a hearing date within a year. That's just their practice. And they really may be that busy. I don't know. I haven't seen their calendars.
Yeah, Josh, this is one of my main concern. Like you say, delay is my biggest problem with all these cases. Some of the cases will involve pharmacy, dispensing high quantity of opioid, Schedule II narcotic. Those delay really are very beneficial to them because I think those fraudulent prescription, they sell such a high dollar amount, it pays to commit those crimes. And if they delay a few months, a year or so, they make millions of dollars, and they get away with it. And my other problem is that the only thing we punish them by just remove the license, and they make so much money off the license. At the end of it, losing a license is not a big deal to them. And I know, from my experience, I feel that a lot of those cases, we just deal with the Board of Pharmacy, just remove the license, suspend the license, and revoke the license, and that's the end of it. But my feeling is that I don't know actually what happened, but a lot of cases not referred to the criminal for prosecution. I see a lot of those technicians, a lot of those diversion, and they just slap on the hand, they lose the license, it's no big deal. And if those organized people dealing with the opioid problem, they just send the next technician to continue to do the diversion. So I think this is one of our biggest problem. What we're having now is continue getting those narcotics into the street due to this delay and a non-prosecuting situation. So I'd like to see in the future we involve a little more when we see those dealing with narcotic opioid. We should refer to the prosecutor to prosecute instead just remove the license. To me, that's not good enough.
I understand what you're saying, and I obviously can't speak for every case that comes through enforcement because I only see the ones that either I'm consulted about or that are mine to prosecute. But I don't think there's any lack of referral by inspectors to criminal agencies. I think they try to get, I've been personally involved in several sort of interagency kind of investigations. The problem has been, until recently, and this is part of the reason for the opioid crisis, I think, if it's not street drugs or what are considered street drugs, the typical narcotic enforcement teams were not that interested in them. They were not that interested in criminally prosecuting diversion of pharmaceutical drugs. Now, maybe that's changing with the, with the emphasis on the opioid crisis and how the heroin and other street drugs have their origins in the use of prescription opioids or dangerous drugs. But I don't think it's a lack of interest on the part of the Board of Pharmacy or Board of Pharmacy inspectors in seeking criminal prosecutions of those cases that has explained the lack of criminal prosecutions to date. I think it's been a lack of interest on the part of either the police agencies or the prosecuting agencies or both. And I don't really fault them, because when they're, although dangerous drugs are obviously a huge source of the opioid crisis, at least from their perspective, and I don't know the actual statistics, but from their perspective, they don't have the same associated violence that, or impact on neighborhoods that they think street drugs have. So I think they were prioritizing those that tend to be, run by gangs and include violence and so forth. So that's what I think was leading to that. I'm speculating, obviously, because every DA makes a different decision about whether to prosecute a case or not. But I can tell you, and Ann, I'm sure, could back this up, that most cases that involve a pharmacy technician, diverting large quantities of drugs, DAs are not interested in prosecuting those pharmacy technicians.
Yeah, how we change that mentality, because otherwise, this opioid epidemic will be continued. If you, sometimes we see hundreds, thousands of those tablets, getting out to the street. So I mean, here is at one hand you want to stop it, but at one hand, you're not gonna do anything about it. There's no fear, there's no punishment, and there's no risk for them to continue to do what they're doing. And this thing keep on going on and on and on. And
right. I mean,
stop?
It's such a complicated explanation that I can give you just a taste of it. I'm not going to give you all of it. But a lot of these large-scale diversions are taking place across multiple counties. And so the individual impact on a particular county may not be that large, but the cumulative impact is, they take the drugs out of Alameda County and immediately ship them down to LA or whatever. There used to be a lot more force multiplication provided by a state, a division of law enforcement in terms of those large-scale narcotic investigations. That you may remember the cut to DLE that happened a few years ago. One of the agencies that was particularly impacted was the Bureau of Narcotic Enforcement that used to do those kinds of interagency, used to coordinate investigations that involved lots of different jurisdictions. That no longer really exists, at least in the form that it used to. So that hole was not filled for a while. I think it's now being filled by more cooperative agreements between DAs. I think this is a constantly evolving process, and I'm hopeful that in the future there'll be a lot more interest in these kinds of cases, because I think there's been more recognition that this is an underlying cause of the street drug use. I think that as we've all witnessed in the last few years, the nation coming to that realization that I'm sure pharmacists and people involved in pharmacy were well aware of long before, but it's sort of a re-education process that's happening across the spectrum, and I think that includes law enforcement agencies, criminal law enforcement agencies.
What you suggest, what can we do to change the mentality? So can we make regulation to, mandatory require the pharmacy get that involved, that or our agency here to mandatory required to refer to for prosecution?
That would be very difficult to do, because setting up the criteria for what would qualify for criminal referral would be difficult. I mean, you can make known to executive staff, which I think you've done, that you want all of those cases to be criminally referred. As I said, I think they all have been, but you can certainly check on that if you want, or you can just ask staff to make sure that they're doing that henceforth, because I don't think you need a regulation or a statute to make that happen. That's policy that the board can set, that any case that would be eligible for criminal prosecution should be referred for criminal prosecution.
As is right now, they got no fear and they got no risk, and they continue to keep on going, doing the same thing.
I understand what you're saying, and so this is the balancing act that we're always talking about, which is, if we want to refer that case for criminal prosecution, that's necessarily going to delay our case. So is the board going to be dissatisfied at some point down the road that the criminal prosecution went forward but was unsuccessful, or the criminal prosecution went forward but didn't find that our particular licensee was a particularly worthwhile defendant, or they flipped our respondent in pursuit of someone larger. So the criminal case doesn't really end up helping us. So what we have at the end of the day is a case that's 3 or 4 years delayed because of the criminal case that comes before the board, and then the board's unhappy about how long it took. So there's all these very difficult decisions that executive staff have to make about when to go forward and how aggressively to go forward on particular cases. And particularly the most serious cases are the most difficult because there's often, as you say, this criminal. So there, as Greg's not there anymore. As Greg mentioned, wow, you're like stealthy like ninja. As Greg mentioned, there are various things you could do in the interim. I mean, you could seek an interim suspension order. That has the same issues of potentially fouling up the criminal case. You could do a cease and desist order administratively. You could get additional statutory authority to do a cease and desist order in, say, large loss cases or large diversion cases. That might be a way that you could go that would sort of go down the middle. It would allow you to take some action while the case is still going forward, but you have to provide a right of appeal. You can't just take people's licenses away or suspend their licenses. So who knows how successful that would be ultimately, and it may gum up the works, but that's certainly a tactic you could try. I don't think there's a lack of referral to criminal agencies as a cause for the lack of criminal prosecutions.
I think we went over this. How many cases? Can you hear it? There you go. I think we went over this last time. How many referrals we've actually done to get for prosecution from DA from whatever county, okay? We didn't have that many. I think it was, we can come up with any. So everything seems to be concentrated in administrative type cases, okay? You work it administratively and criminally, I think is what Albert's going at, we don't pursue it, or at least we don't refer it to whatever county or jurisdiction that's could enforce that. We haven't been seeing any of that. What we do see is a lot of the opiates that are being taken from the pharmacist facilities, and a lot of sometimes they're in very large quantities. And that is a threat to the public because you're talking overdoses and deaths and so forth. So I think that's been a concern.
Right,
Do you think it's that we don't pursue it, or we do refer it to a local police department and they choose not to pursue it? Because I mean, we don't pursue
That's what I was
criminal
specifically
cases.
asking, how many cases were actually referred to any district attorney from whatever county, and I was asking for those specific numbers last time.
'Cause I would
and
think
that
it's
was
pretty
very
high.
low at the time. I don't think there was a large amount, was there?
I know better. I don't remember the specific discussion. What happens is there's 2 times that it would be referred. Initially, one of the things we encourage is when that tech steals, that we want the pharmacy to have the tech arrested, because that starts the process and that puts the individual in the criminal system. Another problem we have is that when they charge the defendant, the criminal, should I say, they charge the value to the pharmacy of the drugs, not the street value of the drugs. And that is another problem because the street value greatly exceeds. Those drugs are worth a lot more on the street than they are in the pharmacy. And had they used the street value, it's far more serious theft. Where we would refer formally, where it would be obtainable to us, is more typically after we finish our investigation, after we do the file, and at the time the investigation report's done, and we'd have to pull files to do that because we don't always have the stats to do that. But generally, we do try to get law enforcement involved because for most of our staff, we take this as a personally, as you do, that this is an affront to public health and safety, and we want law enforcement to be involved because, as you say, they have sanctions we do not.
Yeah, it just seems that you should be able to file something administratively and criminally at the same time. I understand the delays as far as, the administrative case could take a lot longer, okay? But criminally, we should notify every county or every district attorney's office should be getting a copy of that report so they can at least, if they want to reject it, fine, but, to get it out there.
Yeah, so I don't know the actual statistics. All I can tell you is my anecdotal experience. I've reviewed, in my 15 years of doing cases for the board, I've probably reviewed, 1,000, 2,000 cases, something like that. I have seen tons of cases where a pharmacy technician is caught red-handed. They called police, the police come out, no arrest is made. Or we ask for a police agency to investigate, no investigation is done. It just happens routinely. And I think it's an I think I can't offer any explanation other than these were not given priority by police agencies up until now, these kinds of cases. Because from their point of view, it's essentially what they've caught them with typically is one bottle, and they may have a much larger loss, but trying to pin that loss on that individual may be difficult. They may have video surveillance that shows them taking bottles on 2 or 3 occasions. That's what they can prove criminally, and the value to the pharmacy of that particular crime may only amount to a petty theft.
And I'm going back from personal experience as a state investigator with the Department of Motor Vehicles. We file things criminally and administratively against a licensee, and they get filed.
Yeah.
You know, I know there's the monetary part of it, but there's also the large theft and afloat and so forth. And it just seems it would be reasonable to do both.
What's the average dollar amount of the cases that you're working?
please.
Well, I feel.
I think that's our problem.
I feel as an organization here, we're not doing our part to stop this opioid epidemic. I think we should have some kind of policy to refer those criminal case. I mean, if they make it as big as this nationally about this opioid epidemic, if we want to stop it, we have to do our part. We have to start it somewhere. We should refer all those cases for criminal prosecution. And if they don't do it, at least we do our part, and there's a record on their part that they're not doing anything about it.
If anything, just keep tabs as to why they're refusing them. Maybe it's our own investigators that we have that don't have the tools or the training or whatever it may be to collect. You know, there may be something there. Who knows? But we don't have any numbers to point at all.
So I guess going back to your flow, where in your flow would you refer it?
I mean, typically, it's not our office that would do that referral. It would be the board. It would be as Jenny mentioned, typically there's 2 opportunities for referral. One is at the initial outset of the case when we try to get an arrest made. If a pharmacy reports to us that they have, a theft, we want to. I think it's in the standard workflow to say, was an arrest made? Could you make an arrest? That's the first opportunity. Then the second opportunity is once we've either completed or are near completion, or once the board is near completion of its investigation, they will make that referral. And I think that's what Tom is going to talk about, because Tom is one of the people who would be in charge of that.
Okay, Tom, go ahead.
Just for clarity, so they would make that referral before they would send it to you, to the AG?
I don't know that. I'm not the best person to answer that.
Okay.
Yeah. So what I wanted to comment on was, I ran a law enforcement task force, a pharmaceutical drug law enforcement task force out of San Diego for about 8 years before coming on with the board. So there's a lot of issues that come up when we would get a case of a pharmacist or a pharmacy tech who was diverting and stealing. The first thing we needed to do to prosecute a case was to determine if there was going to be, if it was for self-use or distribution. If it was somebody who was self-medicating, we were declining the case. We wouldn't even take the case. Would not be prosecuted by the district attorney's office. So it was an automatic declination. So if there was no evidence and...
Why, can you just say why? Is that because there's no harm to others? It was only harm to the
Because they were typically going to be misdemeanor cases at best. And they would look at that case where it was an addiction problem, and the focus should be to get that person into some type of drug program for rehabilitation. So the goal was not to go ahead and criminally go after them. If there was evidence of sales, then it becomes a felony, and then we would get involved. The quantity alone is not enough to justify evidence of sales. So if somebody's stealing 100 bottles of promethazine with codeine, unless there's some evidence that shows that they're working with somebody else selling that stuff, we have no evidence. And we have declined those cases for prosecution because the DA is going to, somebody has to get up on the witness stand and be able to explain that it is there's evidence that exists, whether it's in the form of text messages or witness statements, or you see people working together, there's got to be something that shows a link to other people to show sales. Otherwise, again, all you have is a misdemeanor case, and you will not get that prosecuted. And we were having that issue with street-level drugs, with large quantities of meth, large quantities of heroin, where if we could not show some linkage to another person, we weren't getting cases prosecuted. A lot of these cases, I think I want to say in 2015 or 16, the laws changed, and a lot of cases were lowered from felony, where you could charge people with felony possession. Most drug cases are now misdemeanor possession cases, and they're just not going to get prosecuted. So typically, when there is diversion within the pharmacy, typically the pharmacy owner, especially even some of the chain pharmacies, their first call is to law enforcement before it's to us. So that referral is already made to law enforcement, even if it's a small amount. So and we know that up front. So for us to turn around and go back to that same agency and refer it a second time when they've already declined the first time, really.
That's when they report it to a law enforcement agency.
Correct.
I'm talking about when our inspectors are out there doing their investigations and they discover some of this stuff, or they come across it, and they put their things together, and it could be filed both criminally and administratively. At least it could be reviewed by a district attorney of whatever county it may be.
Well,
You were in San
right.
Diego, it could be down here in one of the
And those
counties down
cases are
here.
I think those cases where we independently find large quantities of drug diversion are few, and those cases are the ones that you probably have seen get referred. Because
Yeah, that's
because
what
the
we were
larger
specifically
quantities,
asking
the larger quantity, if there's a loss of hundreds of thousands of pills, there's typically a number of related ways that comes to light, whether it's through wholesaler suspicious orders, whether it's the owner, or if it's a chain pharmacy, their internal loss prevention. They have inventory triggering mechanisms to identify large losses. So there are some, maybe we miss a couple, but I think typically.
We get to hear them here, and they're some of them are some real outrageous things that come across here. Okay, we see it, and I see the frustration with some of my colleagues here that, how can this happen? And then it didn't get referred criminally. We handled it administratively only.
Let me just point out
oftentimes-
one other thing that's a limitation on it, and I don't mean this as a cavalcade of excuses. We totally agree that all these cases should be criminally prosecuted. We totally agree that they should be criminally referred. But there is a limitation on the jurisdiction and the kind of evidence that could be gathered by this agency, because this agency only deals with the licensees. And typically the evidence of distribution that you might be looking for is not going to be within the four walls or within the context of the legitimate distribution chain. It's typically going to be the outside non-licensee criminal gangs or whatever it may be. This agency does not investigate beyond the walls of those the standard distribution chain. So we're never going to have, unless someone has, as Tom mentioned, happens to have text messages that we get, and typically those are not even captured by our inspectors. They're typically captured by the chain pharmacy or whatever, by their loss prevention officers. Unless we happen across an admission or a text message or anything like that that says that someone is distributing, we're typically not going to have evidence of distribution.
Because oftentimes the employee was just being terminated by the company rather than reporting to the police. So then I understand the issue with Ricardo and Albert. So that's the area that we're so concerned. The only deterrent for these people not to commit this kind of diversion is that at least they know they will be criminally prosecuted, as opposed to just take my license away. I'll be a waiter next week. I mean, and then have somebody else to go in and do the same diversion again. So if it needs a statutory change, or, I mean, what is your recommendation?
Well, I mean,
based
you
on the
guys are
frustrations we
really swimming against the current in terms of what's been happening the last several years in California. As Tom mentioned, there's been a dilution of the penalties available for prosecution of drug crimes. There's been a lot more emphasis on drug courts, on diversion, all kinds of things. It's just not an area of huge emphasis to prosecute what are considered low-level drug crimes, particularly if they're just drugs of possession or self-use. Large-scale distribution, yeah, but that typically involves federal authorities more than state authorities. So I just don't know that this legislature, for instance, is going to be at all interested in increasing the penalties or even increasing the ease of investigation or prosecution for those kinds of crimes. I just don't know. I mean, maybe that's one approach to the opioid crisis that this legislature would be willing to take, but it doesn't seem like that's the way this legislature is leaning.
Well,
It doesn't seem like we have the resources. I mean, I know to go out there and put a whole case together and follow it through as a criminal case, okay? I get that part, but I'm talking about just a referral. We come across it and we refer it over to whatever jurisdiction, whatever county that may have a task force going on at the time, and hopefully they would follow up on that stuff. I don't know.
Well, I think one thing that's clear from this meeting and that I'm sure executive staff will implement is a uniform referral policy for all cases in which a criminal prosecution would be possible.
One more statement, okay? In order to stem this epidemic, we have to be a little more proactive. Right now, I feel we're not doing that. We have to do our part. Since with all the limitation, what you speak about, maybe we should, as a board here, when we see those cases, diversion or the fraudulent prescription, or when certain pharmacy order high quantity of a narcotic, we should inspect them, give them a visit, and make sure they are, the prescription are legit. So maybe we could do through that route instead of with all this limitation you have. So we have to do something. I mean, we cannot let it go on the way it's been going on.
If anything, just how many cases we referred, maybe give us a heads up so we at least can know where to point at or where we can concentrate some of the help that we need here.
Well, I think to get an accurate picture, you would have to include, essentially cases that were self-referred, cases that had a referral to the police agency at the outset of the case by request for arrest by the pharmacy or whatever. I think that probably some number that includes all the cases that were referred to a criminal investigative agency, whether or not a prosecution was brought. I think probably board staff were only giving you the cases where prosecutions were actually brought, which is a much smaller number than the number where they were referred. But I think that's probably a stat that wouldn't be easy to come up with because it's not something that you're tracking, but you could probably come up with some sort of stat on cases referred.
Well, it depends, because part of the time, generally, the most likely referral would occur when we're working side by side with the investigating agency at the front end. At the time that they go out, they take the report, we get the police report, we go out and investigate, we contact sometimes. You're right, the big distribution models, we can't get into that because we won't know about it. We're going to get the bottle of pills. We're hoping that reconciliation reg, and part of the reason it's so integral to where we're going to go with that reconciliation reg, it's going to help them identify when they have a loss of the twos much quicker than once every 2 years when they do the biennial inventory. And so we are just at the front end of implementing that requirement. That is going to give us data that we don't have now. And one of the things we have in the works is getting the inspectors out to do performance assessments to see if they're compliant with the reg, so that they'll at least know when the drugs are being stolen from the pharmacy, which now can go on for 2 years or even longer sometimes. So we're hoping that will help. One of the things that I've been standing up here so long for is, Tom, Mr. Lennox, would you please introduce yourself to those up here that don't know who you are, and a brief overview of your background in the last 2 years. 2 sentences, not a full resume, please.
1 minute.
Chief of Enforcement, I oversee the drug diversion, fraud, probation, the prescription drug abuse teams for the Board of Pharmacy. I've been here going on about 1.5 years now.
Tell them where you came from.
I retired after 30 years with the Drug Enforcement Administration The last 8 years, I ran a pharmaceutical drug task force that had California Department of Justice, Sheriff's Department, Homeland Security, DEA, California Department of Healthcare Services. We were based out of Southern California and handled anything that involved criminal violations with pharmaceutical drugs.
Well, Josh, I think you know our concern right now.
Yeah, I do.
Okay, okay, that's it.
And I will say, just, yeah, sure. One of there are many things that will mark the tenure of Virginia Herald at the Board of Pharmacy, e-pedigree, compounding, regulation, all those kinds of things. One of the things that I think has really been a hallmark of this particular executive staff has been really taking drug loss and drug diversion seriously. Sometimes to the consternation of my colleagues, who don't necessarily see the seriousness that some of the executive staff attach to them, but we really are appreciative of, there's been a consistent message over the last, 5-7 years that we will not tolerate large losses, and that we're going to hold not only the individual responsible, but the PIC and the entity responsible. So that's definitely been a change in what I've observed over my 15 years with the board. Yeah, we will move on now. So then once the case is filed and you've gotten a notice of defense, then you get into what can be a short or a lengthy settlement negotiation process, because we cannot bring every case that is filed to hearing. We would quickly become bogged down and not able to prosecute any cases. So we depend on settling somewhere between 80 and 90% of our cases in order to be able to get our work done. So that means, and most cases have a settlement value. Everybody sort of knows this case is worth this. Sometimes defense counsel have a different understanding of what a case is worth than our client agency does, but that's natural. And it's an adversarial system that's designed to fight until you reach a settlement. So these are all the kinds of things that we look at as attorneys in terms of assessing our case. There's different options. Diversion is not really an option so much anymore. It used to be back in the day before CPEI and so forth. There used to be pathways, at least for some of our client agencies. This was most common for BRN. That even once a case was filed, you could send that person to diversion as an alternative to discipline. That was taken away by CPEI and the uniform standards. But there's still diversion as sort of a form of settlement, as PRP or something like that. Surrendering the license, probation, cost recovery. And what's really key is that although someone like myself, who's a graybeard at this point, has a long tenure and can see sort of how one case relates to another, I have that experience with Pharmacy Board. I don't necessarily have that experience with all of our 40 client agencies. So it's incredibly important to have staff with long tenure and long experience who have a global view of where this case is in the ranking of how important our various cases are, what the board has said about its priorities for different kinds of cases. So that it's really important to make sure that we have the check of staff giving us settlement terms or giving us lack of settlement terms to make that decision consistent with other decisions that the board, and that's always going to be a little bit of a catch-up process. As you know, the composition of the board is always changing, and so the board members may have been more hard line at one point, and so we're really rejecting more what they perceive to be too lenient settlements, and so board staff are trying to predict what's going to be acceptable to the board, and that's a really difficult thing sometimes because you're all individuals and you all have different points of view, and you're not even consistent on every case. You might see someone as a little guy who's being given a raw deal versus a big guy, whatever. So board staff have to try to anticipate that, and there's often a lag time. You may have a couple or a few more lenient decisions in a row, and board staff have to kind of wait and see, was that specific to the facts of that case? Does that indicate a more general trend toward leniency? Because they're not allowed to, essentially ask you that. You can only act as a body, and the only way you can reveal your predilections or your preferences is by way of the decisions that you render. And so the board staff have to understand what you're communicating or not communicating. They gain some information from from closed sessions and so forth, but they don't, that's just individual board members speaking. That may not necessarily reflect the will of the board. So that can cause some inconsistencies between what you think you've expressed as a preference and what you see in either proposed decisions or stipulations that come before you.
Well, I would say that any case that comes before us when we're all together, we work very hard at trying to be consistent, and we've actually, I think Ann now sometimes brings a list, to prove to us, here's how we've handled these similar types of situations. But it also seems like the DAG that's involved changes it a little bit, because when we're reading the the summary, some are very well written and we understand exactly what's going on, and some it's like Reader's Digest version and like key facts are missing. And then we'll even like get here together, and sometimes even our board staff seems like they weren't 100% involved in really making sure that it was a consistent negotiation. It was just kind of the DAG did it, and so then we're put in a situation where we have to drag out the case longer so we can pull everything back in. So I mean, I know our board really wants consistency. We talk about it every time we're in closed session, and so I don't know, and we aren't there yet. I don't know how we get there, but it seems like that is a challenge.
I mean, everything you're saying is true and provable. There are variations in both quality and viewpoint of individual attorneys in my office. There are individual variations in how much they think they need to tell you about a particular case. Maybe they think it's an easy adopt and you shouldn't need that much information. I don't know. I obviously can't speak to why certain letters of recommendation are less valuable than others. But I will say that I think staff are always heavily involved in settlement negotiations, at least my personal experience. Obviously, I don't know every case, but I've never had a settlement negotiation in which I was going off on my own or not explicitly guided by staff in terms of what they think the board would find acceptable in that particular case. And actually, one of the difficulties is that in order to ensure that consistency, I think Ginny and Ann have felt a great deal of pressure to be personally involved in almost every settlement negotiation, which is a huge amount of work for them and creates a little bit of a bottleneck in the sense that they can only, be involved in so many things on a given day. So we have some other client agencies that at least appear to give other people more settlement authority. I don't think they actually do, because I think those people are going up and discussing it with their supervisors, but there's a little bit more of a flat administrative structure at some of our other agencies, but you can't have both. Like, if you really want consistency and you really want every case to be scrutinized to the level that you would expect, there may be only a couple or a few people that you would trust to do that level of scrutiny, and then that means that those cases might be slowed down by the fact that it takes a little longer to get the time and the energy of those people to do that scrutiny.
I mean, it just seems like you could, to some extent, it won't work 100% of the time, but you could build like a matrix that, if here's the algorithm, if the person did this and they did it this many times and it was this egregious, then boom. And if it's, almost.
Well, if you were going to do that, it would have to be a regulation. Because anything you would do that would guide the decision-making of the board that was not in regulation, or just guide the decision-making of board staff, would be considered an underground regulation and not appropriate. So. Sorry, go ahead, Laura.
When you're done.
Anyway, so the disciplinary guidelines are intended to be that matrix. They're written in sort of general terms and obviously allow for some discretion and some judgment about what fits into which category. But the idea of the disciplinary guidelines is to be the board's expression of what kinds of offenses are worth what level of discipline.
And actually, that's exactly what I was going to say, is that the disciplinary guidelines are actually the board's means by which it sort of establishes the parameters of what happens. And I will also just share with the board that you're not unique in seeking that consistency somewhat unsuccessfully. And I see you do it successfully, but I think that every case is so unique that there's some variance that you are going to see.
Josh, let me just interrupt you for a minute. how much more time do you need to go, or should we take a?
I don't know. It really depends on you guys. I have 12 more slides.
Why don't we take 5 minutes break first before you continue? Okay, let's take a break. Thank you.